What's up, anybody? Three cases are called 23 CR 110, first degree felony, aggravated assault, family violence. There's two cases. I'm not through. 23 CR 120, gotta work through these here. Third degree felony, an indictment, a third degree felony of unlawful possession of a firearm by a felon. And in that case, stand by. As the previous case, one or more prior felony convictions are alleged. So this aggravated assault in 110, it's enhanced to, correct me if I'm wrong, no less than 15.
That one, Your Honor, they're not in sequence, so it pushes it up to
one level. It's a first degree felony in paragraph 1 with prior felony convictions. It would enhance it to 15 to life.
Yes.
And then in 23 CR 120, it's a third degree felony with a prior conviction, so that gets enhanced if found guilty of all of that to a second degree felony punishment. And finally, 23 CR 340, aggravated assault, family violence. Again, all of these are on the same date. It looks like on or about February 8th. Yeah. 23. Is this re-indicted from 110?
That's correct.
So here, we can shred 110, right? We don't need that.
First, right away this hearing becomes far more serious than an ordinary bond review. Prior felony convictions can dramatically increase the possible sentence raising the stakes for every decision the judge is about to make. Second, now the court turns to the probable cause affidavit, the document prosecutors rely on to explain why these charges were filed. What the judge is about to read could heavily...
That's correct.
So here, we can shred 110, right? We don't need that.
That's correct.
All right. So what did you do? Just add a prior conviction?
No, Your Honor,
first one?
As far as this, it had to be re-indicted because it said the previous one it said caused physical injury, but in this case it was just exhibiting the weapon and threatening.
So it was also changed from a first degree to a second
degree, yes.
So
it'd be
that's a second degree felony then, but you have two prior convictions which look like they're not in sequence, are they?
No, Your Honor.
So it's enhanced to a first degree felony. So you have a second degree felony punishment and a first degree felony punishment. Unlawful possession of a firearm by a felon and family assault. Okay, so and 110 here, that's gone. That's out of here. So that's not part of the game that we are playing in this case.
You need to make sure, Your Honor, that one is dismissed because it's still showing up.
Yeah, that needs to be dismissed. Yeah.
Part of our request, Your Honor, is to make sure they get so as well as money is paid.
What are his bonds now, please?
Like 60 and 10, Your Honor. 60 on the aggravated assault, 10,000 on the felon.
Set those bonds. Curiously enough, I'd like to know. Because they're woefully inadequate under these circumstances that I'm looking at with prior criminal history and the facts of this case. Here, I'm reading the probable cause affidavit, which I'm sure would have been read, but let's see. The victim says to the defendant she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her, and hit her in her stomach. It was a revolver. Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm.
First, right away this hearing becomes far more serious than an ordinary bond review. Prior felony convictions can dramatically increase the possible sentence raising the stakes for every decision the judge is about to make. Second, now the court turns to the probable cause affidavit, the document prosecutors rely on to explain why these charges were filed. What the judge is about to read could heavily influence the bond decision. Third, this is the turning point of the hearing. The prosecution wants much higher bonds while the defense argues the defendant has already waited nearly a year behind bars, which argument will discussion beyond legal arguments and focuses on the alleged violence itself. Moments like these often reveal the judge's reasoning before the final ruling is announced. 5. Erase the decision everyone has been waiting for. After reviewing the allegations, criminal history, and public safety concerns, the judge is ready to explain why the requested bond reduction will or won't be granted. 6. Every courtroom hearing reminds us that bond decisions aren't about determining guilt or innocence. They're about balancing public safety, legal rights, and ensuring
Let's see. The victim says to the defendant she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her, and hit her in her stomach. It was a revolver. Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm. Then it was located and arrested. A silver revolver with a wooden grip was located in the defendant's closet, bedroom, underneath some clothes. There was a loaded Taurus 38 caliber revolver. So he was booked in for unlawful possession of a firearm by a felon because he has 2 prior felony convictions. And these facts also resulted in him being indicted for aggravated assault, family violence. Anything else? What do you want to add from the state and the defense?
Your Honor, yeah, like you said, I believe they were set way too low in this case. State,
What are you asking?
On the assault with a deadly weapon, the state would ask for $150,000. $50,000 on the felony possession of firearm.
I don't know, we request a lower amount. Almost a year now waiting.
I don't, so what's the point of that? That doesn't purge the facts.
No, it does, but I'm just, it's part of just the narrative to everything. It's just,
Okay, narrate.
Your Honor, we have requested to set on trial. It was set for, I believe, last week. We were on a trial docket. We did not get reached for trial. This is something we intend to try and get resolved. But in the meantime,
I want to ask this. Defendant is not eligible for probation, correct?
Yes, correct, Your Honor. Yes.
There's a gun in his home, right? And it happens to match the firearm that was described by a complainant in another case. So let's talk about the circumstances in this case, if you want to or not. What do you say about the firearm?
Your Honor, it was found, it was not found on him. I would have made the argument that I think
Was it his home?
it was
It was a good one.
Let me, who lives there?
Who?
But Your Honor, that's one of our arguments is that it wasn't found on this person. There's a whole respect here, Mr. Control.
Which doesn't need to be on this person, right?
No, but you still have, the street, it doesn't have to be on the person, but you still have to put it in carry custody control. There's limitations on that. Because it wasn't in his home by himself. There's some other arguments we're gonna make, but we'll make that a trial. It's not for a year. But Your Honor, we just requested that we felt that this was too high, especially also.
What about the assault of allegedly beating on a lady, which is about as ungentlemanly as it gets? The court has little tolerance for a man doing that, unless he's defending himself, of course. But I can't imagine the way I grew up, the way everybody should grow up, where ladies should be treated like ladies. I guess your story is she beat herself up to impress the police when they showed up. All right.
Your Honor, one of our issues was that currently, like I said, both cases are inactive. We want to make sure the older one gets dismissed, that takes one less bond off the table for him to have to pay. As we've got here this morning, they're both still heading the pending. So that was one of our arguments. I think we're already ruled.
What about it?
Well, I think the one that's been re-indicted from needs to be dismissed because it's no longer active. But I think
Okay.
yes.
That doesn't make sense. Yeah,
And Your Honor,
that is certainly correct.
Yes.
He doesn't need that shouldn't be against him to
not showing a bond on that one in my system. It's showing it added an error to the side, and the actual bond is on the new
Okay, just make sure that Joe has that correct. That's what our issue is. They're trying to.
It looks like they're trying, it's probably one of those problems of transitioning in this gigantic data system
Yes.
that we have suffered through in the last few months. But at least they put in something that he is not on, he is not disqualified or required to set a bond on that case that's still that was to be replaced, that's still floating around in the data system. So that should not be a prejudice to him.
But Your Honor, his family has attempted to bond him out due to the fact that there is multiple cases to bond out in the amounts. He has been unable to do that. Your Honor, he is from here. He has family here. He has relatives here. Everybody's here. He has connections to the area. It's not a flight risk. There's no doubt about that. So then it comes down to the big question that will always come down to the dangers of society. This is a violent crime. We understand, but this is a targeted crime. But this is not a random crime of violence. This is something coming out of a relationship.
I mean, it goes against the whole idea that our American society is built around a family unit. But somebody allegedly beating up on the female portion of the family unit is going to be apt to ruin that relationship and cause hostility. This, I think our moral nature is one of peace in the home, which this defendant is charged with completely and totally eradicating.
Your Honor, I think if the court would lower his bond, but add conditions in there where this conditions are always in there, but no, obviously stress that if the court wanted to add a ankle monitor or some other monitoring device to help prevent that or comply with that. But we would request that it's come down to a lower amount in the range of $20,000. I believe $60,000 based on these facts is high.
They're $100,000 in each case. These are atrocious, but his criminal history especially, he has no room for error, but to allegedly beating on the family member, and also being charged with a firearm, which has gotten him in trouble in the past as a felon, and that is disqualifying him from his privilege of right. And I don't find that to be unreasonable under this fact situation and his criminal history. Also, if he does post a bond, he must have, he will be placed on home confinement, not the victim's home or the complainant's home, some other place that you're going to live. And you must have a GPS and leave home for certain necessities that the court would describe and spell out when and if you are bonded out. Let's set this for trial. Is that what we're doing?
It's already been on the product.
Let's try to get this as soon as possible.
Yes, sir.
And the defendant is ineligible for probation.
Yes, sir.
All right, so let's move forward on these things as soon as possible. All right, that's
Of the hearing, the prosecution wants much higher bonds, while the defense argues the defendant has already waited nearly a year behind bars, which argument will persuade the judge. For RT, notice how the judge shifts the discussion beyond legal arguments and focuses on the alleged violence itself. Moments like these often reveal the judge's reasoning before the final ruling is announced. 5. Erase the decision everyone has been waiting for. After reviewing the allegations, criminal history, and public safety concerns, the judge is ready to explain why the requested. Now the court turns to the probable cause affidavit, the document prosecutors rely on to explain why these charges were filed. What the judge is about to read could heavily